Hello, my name is Allison Wright, and I'm a partner and shareholder at the law firm of Pappas Wright, located in Rock Island, Illinois. I'm pleased to be providing this training on behalf of the Illinois Community College Trustees Association, and I appreciate you joining us for this session today. In this podcast, specifically, we're going to be talking about the primary piece of legislation that applies to community colleges, and that, of course, is the Illinois Community College Act. Specifically, we're going to first talk about background on the community college system, main highlights of the Act as it relates to trustees, and then of course we'll talk about some trustee takeaways so that you can put those into practice today. So let's get started.
It's going.
Okay. As trustees, each of you have dedicated and volunteered a large amount of your time to overseeing your community college. In turn, you are dedicating a lot of your time and energy to the Illinois community college system as a whole. And community colleges, sometimes referred to as junior colleges, have a very special connection with the state of Illinois. And perhaps some of you are familiar with that special connection, but for those that are not, I'm excited to share with you that the very first community college in the country started here in Illinois. And today, this trustee training is all about what later evolved into your governing community college law, the Illinois Public Community College Act. So today, we're going to cover the following: a historical snapshot of community colleges leading to the Illinois Public Community College Act, main highlights of the Act for trustees, and specific responsibilities that come from that, including adopting and enforcing all necessary rules for management, requiring annual training, different financial responsibilities, duties as they relate to units of instruction, personnel responsibilities, and then of course, as always, we will end with some trustee takeaways. So let's start with a quick history lesson on community colleges in Illinois. In 1901, Joliet Junior College became the very first junior college in the United States. It was started by William Rainey Harper, who was the president of the University of Chicago. Joliet Junior College opened with just 6 enrolled students. The purpose of the junior college was to serve students who wanted to stay within their community while pursuing a college education. And it originally included only those students within Joliet's high school district. But then, after a few years' time, its reach expanded and it included students outside of that district. In 1931, the first Illinois Community College law was passed, and it was specific to Chicago. Specifically, it allowed the Chicago Board of Education to establish one junior college offering 2 years of curriculum past high school as part of the Chicago public school system. Now, for the next 30 years, the community college laws in Illinois saw many changes and saw a lot of growth. In 1937, the Illinois Junior College Act became law. In 1943, referendums were allowed to establish tax rates for education and building funds for community college operations. In 1951, laws explaining standards and procedures for establishing junior colleges went into effect. In 1959, there was a significant expansion, and separate districts were allowed to organize territories as community college districts. Now, while the state of Illinois is hailed as the origin for community colleges, today I am presenting at Black Hawk College located in Moline, Illinois, and Black Hawk College has its own distinctive first as well. Black Hawk just celebrated its 75th anniversary, wherein it began as Moline Community College in 1946. At that time, Black Hawk was an extension of Moline High School, much like the other junior colleges, which all derived from a K-12 school district or were an extension of that district. In 1961, Black Hawk College became the first junior college to be separated from its underlying K-12 school district. In 1961, that same year, the Illinois Board of Higher Education was created. In 1965, the Illinois Public Community College Act became a law, and following the same model established by Black Hawk College, it separated entirely the Illinois Community College system from those K-12 school districts. In 1973, the term junior college was officially changed to community college by statute, and of course, Joliet Junior College still goes by that name due to its historical roots and the fact that it is the original founder of junior colleges in this country. Now, today there are 48 community colleges in Illinois and over 1,200 public community colleges throughout the country. And at your community college, today you serve on the Board of Trustees under the authority and governing standards of the Illinois Community College Board and the Illinois Board of Higher Education. And the law that created separated community colleges, the Community College Act, continues to be that primary governing legal authority for all that you do as trustees. So we're going to cover 5 main highlights from that act as it applies to trustees. First and foremost, a primary and general duty of the Board of Trustees in the Community College Act requires the board to adopt and enforce all necessary rules for the management and government of the college. Now, this is a very broad and substantial duty. As trustees, you're required to adopt policies that govern the overall management of the college. And throughout the different community colleges in the state, those come in different forms. They could be board policies, they could be handbooks, administrative guidelines, they could be department policies, they could also be part of your collective bargaining agreements. The policies that trustees are responsible for are broader than just those policies that govern trustee behavior, meaning while you're responsible for establishing board policies for you and your fellow trustees to follow, your authority and responsibility has a greater reach. So as a general rule of thumb, you'll always want to remember this overarching duty and its application to you as trustees. The Community College Act also requires each trustee to complete leadership training. Specifically, any voting trustee who is elected or appointed to fill a vacancy of at least 1 year must complete a minimum of 4 hours of professional leadership training during the first, third, and fifth year of the term. The law recommends training on specific topics, many of which are covered in other ICCTA trainings, including the Open Meetings Act, the Freedom of Information Act, community college law, labor law, contract law, ethics and fiduciary responsibilities, and financial oversight and accountability. Now, the training required by this section may be provided by individuals who are approved by the state board. And there is a public reporting component to this as well. And the college must maintain on its website the names of all trustees who have completed the training requirement and those who have not completed the requirement. So there are different ways to meet this requirement, and the topics are not limited to the ones I just named, but as a board, you'll want to make sure you're aware of compliance deadlines for that. Now, we just talked about the history of the Community College Act and the board's duties to adopt necessary rules and complete annual training. And now we're going to talk about the board's duties as those relate to financial decisions and personnel decisions. Now, as you all know, the board has an enormous amount of responsibility when it comes to the financial decisions of your college. Many of your duties relate to the college's use of its funds and how those funds are utilized. And the Community College Act has numerous provisions regarding financial responsibilities. But for this training, I'm going to touch on a few of them. First, contract authority in Section 3-27.1. The first here is the requirement that the board get involved in and approve contracts that exceed a particular threshold. Under the Community College Act, any contract for the purchase of supplies, materials, or work involving an expenditure of $25,000 requires approval by the board. Now, this $25,000 threshold can be set to a lower amount by board policy, but your board policies cannot, by contrast, have a higher standard. The Community College Act sets the bare minimum. The Act also requires certain contracts be awarded to the lowest responsible bidder for those supplies, materials, or work. Now, there are a number of exceptions where the board, and therefore the college, is not required to award the contract to the lowest bidder. Under the Act, there are a number of exceptions. So while the board might not be required to do it in all instances, some of those examples of exceptions include a contract for services of individuals who possess a high degree of professional skill, when the ability or fitness of the individual plays an important part. An example of that would be a contract for college legal services. A contract for the printing of finance committee reports and departmental reports is another exception in the law. A contract for the maintenance or servicing of equipment, contract for the purchase, use, delivery, movement, or installation of data processing equipment. And another example is contracts for goods or services procured from another governmental agency. Now, there's other exceptions, but those are just some of the examples I've provided for today. Now, the second financial responsibility we're going to talk about is the annual budget. This is not just an exercise each year. As you know, it is a statutory requirement that the board adopt an annual budget before the first quarter of each fiscal year. Now, the annual budget must specify for each item not only the amount needed, but also the purpose for each item. It must include a statement of the cash on hand at the beginning of the fiscal year, an estimate of the cash expected to be received during the fiscal year from all sources, an estimate of the expenditures contemplated, and a statement of the cash expected to be on hand at the end of the year. Now, the annual budget must be made available to the public at least 30 days before it's voted on, and then the annual budget has to be filed with the state board. Now, the last financial responsibility, again, there's many that I'll touch on from the Act, is the requirement to conduct an annual audit. Section 3-22.1 of the Community College Act requires the board to conduct an audit at the end of each fiscal year by an accountant licensed in Illinois and appointed by the board. The audit must include a verification of student enrollments and a statement of the scope and findings of the audit. Under the Act, the board may not limit the audit to the extent that that limitation would impact the auditor's professional opinion. So in other words, the board may not direct the auditor to limit the scope of review if such review would impact the ultimate findings of the audit or the auditor's opinion. And then again, copies of the annual audit are then filed with the state board. Now, in addition to these financial duties, the board has a broad responsibility to oversee and approve new units of instruction, research, or public service. The term new unit of instruction, research, or public service means that the establishment of a college, school, division, institute, department, or other unit, including majors, curriculum in any field, new branches, and new campuses. And I've included the full term here on this slide, but I won't read it to you. Notably, the term new unit of instruction does not include reasonable and moderate extensions of existing programs. So the Community College Act vests the authority to establish major program or curriculum changes with the Board of Trustees. And of course, the exercise of that authority, whether it be approving or denying new programs or majors, can have a huge impact on the college as a whole. But it would be helpful to note the distinction here in authority as a key takeaway, and note that the distinction, the definition, is between new programs and extensions of existing college programs. Now, the fifth category of responsibilities I'm going to touch on from the Community College Act has to do with personnel decisions. Specifically, I'm going to talk about the board's duties to hire and set compensation for specific employees, the limitations on employment contracts, and the law's application specific to the office of the president. So we'll start with the board's duty to hire and set compensation. Under the Community College Act, the board is responsible for appointing and setting the salaries of three categories of employees. First, of course, the president of the college. Second, other administrators. And then lastly, all teachers. The Community College Act requires the board to make those appointments and set those salaries. As such, the board, as you know, votes on matters such as employment contracts given to administrators, which sets their salaries, and also provides some of their terms of employment. Section 3-42 also requires the board to employ all such personnel as is, quote, needed by the college. And as part of that, Section 3-42 requires the board to establish policies governing employment and dismissal. Now, there's a fine balance between establishing policies and overreaching into the day-to-day operations of administration. But here, the Community College Act places an affirmative duty on the board to set those employment policies. So a natural extension of that requires the board to oversee the implementation of those policies when they are put into practice. Now, as I said, the second personnel topic I'm going to touch on is the Act's restrictions on employment contracts. We know that the Act requires the board to employ certain individuals in certain positions, and we know that the board is therefore responsible for approving certain employment contracts, namely with administration. A little over 6 years ago, after some turmoil and legislative efforts to curtail golden parachutes, a series of amendments hit the Community College Act, and they placed limitations on employment contracts and on the contract of the president. So let's look at Section 3-65's employment contract limitations first. Section 3-65 applies to any employment contract that was created, amended, renewed, or extended after September 22, 2015. And the contract limitations include severance may not exceed 1 year's salary and benefits, the contract may not have a term longer than 4 years, the contract may not include any automatic rollover clauses, and all renewals or extensions must be made during open session by the board, and the contract itself or the amendment to it must be made publicly available 48 hours before the meeting where the action is to be taken. Now, there's a different statute which further limits severance pay to college employees. So while the Community College Act provides a limitation of 1 year's salary, the Illinois Governmental Severance Pay Act actually provides greater restrictions and further states that any employment agreement with a community college employee cannot have severance exceeding 20 weeks of compensation and cannot provide any severance if the employee has been fired for misconduct. Now, misconduct under that statute is a very broad definition, and it has a significant impact on the way severances or separations may be addressed. Now, the Public Community College Act has a number of provisions that apply specifically to the office of the president, so we're going to cover those. In Section 3-70, which is entitled Employment Contract Transparency, requires any action on the formation, renewal, extension, or termination of the employment contract of the president, and it requires those be made during open session at a board meeting. Section 70 further requires a heightened level of public notice. First, the board must give public notice of the proposed principal financial components from the contract. Now, of course, this refers to things like the annual salary and any other forms of benefits or compensation. And this is most easily achieved by posting a copy of the contract to be approved at the time you give notice, consistent with the Open Meetings Act. Secondly, the Community College Act requires the board to take specific steps before giving the president a bonus that's based on performance or incentives. Under Section 70, any performance-based bonus or incentive-based compensation to the president must be approved in open session, of course. And on top of that, the performance criteria and goals upon which the bonus or incentive compensation is based have to be made publicly available no less than 48 hours before acting on the bonus. Now, the board minutes, packets, or annual performance criteria and goals concerning the president must be made available to the public on the college's website as well. And speaking of annual performance criteria, the Community College Act requires the board to conduct an annual performance review of the president, and that annual review has to be considered when the board contemplates a bonus, raise, or severance agreement for the president. Now, the Community College Act has many regulations, and it governs many more behaviors of the board, from elections to conflicts of interest to tax levies. And with limitations on time, we of course have not covered them all in today's podcast. But for some trustee takeaways, I will leave you with the following. 1, remember the state of Illinois is the historical landmark for community colleges throughout the country. What were once extensions of high schools are now combined as the Illinois Community College system that is responsible for educating so many students throughout our state. Remember your annual financial obligations to your college, the annual audit, and the annual budget, and keep those principles in mind as you make decisions at each board meeting throughout the year. 3, remember to think big picture about what the college offers its students and the community, and consider the role you play as trustees and as a board in approving new programs, majors, or curriculum. 4, remember your role in defining who the college's employees are, from appointing the president, administrators, and teachers, to determining what employees may be needed overall. 5, remember the board is generally responsible for setting employment policies that govern its workforce. You're not responsible for the day-to-day administration of those policies, but you are responsible for setting standards and procedures that your employees will be governed by. 6, remember there are contract limitations imposed by Illinois law. Severance cannot be given to anyone fired for misconduct. It can't exceed 20 weeks. Employment contracts cannot exceed a set 4-year term. And then lastly, remember your ongoing obligations to complete annual goals, objectives, and performance reviews for the president. As your employee, you never want to lose sight of your management responsibilities that relate to that office.